Okay, so you make a big mistake, you land yourself a DUI, and you know for sure you've been arrested for a DUI, they're charging you with a DUI. What do you do at this point? Well, in part one, I talked about what happens when you're arrested for a DUI, leading up to the point where you're taken to court and the judge sets bail, right? Now, in this part of the series, I'm going to talk a little bit more about what happens in the court proceedings and what happens after you've been formally charged with a DUI. So let's go over the 5 things that happen once you've formally been charged with a DUI. So the first thing that happens is you're going to get an initial court date. The initial court date is going to tell you what's happening with the case. In most situations, it's not going to be a trial date. They're not going to just set one court date and that's it. It can happen, but that's usually not the norm. Usually it's some initial status hearing date. It can be referred to as a trial date, but it's possible that the trial may not go forward at that time. Usually there hasn't been enough time to prepare all the evidence and for the attorneys to be ready for trial. So in some jurisdictions, they'll list it as a trial date. It may not go forward. In other jurisdictions, they'll list it as a status hearing date. And it's really just a hearing to determine if you are going to enter into a plea, if you're going to enter into some type of agreement, or if you are formally going to set a trial date that you know the case is going to move forward at. So the first step is that some initial court date is going to be set. Now, the second step is that you're going to go through the discovery process. In criminal cases, discovery is really the process where the prosecutor provides you with some type of evidence that they have towards the charges. Usually at a minimum, they have to establish probable cause to charge. And so that usually requires some type of initial complaint or police report that outlines what the probable cause was for arresting you in the first place and what evidence they may have towards your case. Potentially, it may include the witnesses that they have in your case. If you're in a jurisdiction like Washington, D.C., where the officers here use body camera footage, then during this phase, the prosecutors would be required to provide body camera footage to your attorney to make sure that your attorney has all the evidence related to your case. And so the second thing that happens is that the discovery process starts and you get the reports and the evidence that is related to your case. Now, the third thing that can happen is that you can enter into a program. Oftentimes, if this is your first DUI, there are usually first-time DUI offender programs. Most of these programs require intense, maybe drug and alcohol treatment. Some of these programs require that you do classes as well. In DC, they have 3 different types of classes that you have to do for these types of programs. And so oftentimes, if you enter into a first offender program or some type of DUI program, what will happen is that the case is supposed to get dismissed at the end. There's no point in you still having a record after this if the case is not dismissed. Then at that point, you might as well go to trial or, potentially be found guilty or plead guilty, right? So usually for a program, there's some benefit to you where at some point in time, it's supposed to get dismissed. Now, that doesn't mean that it won't be on your record. There may be a separate process where you'll have to get it expunged or sealed, but usually these programs are created so that you can do something in exchange for a dismissal of the charges. And that's how those programs usually work. So the third thing is that you may enter into some type of DUI program. The fourth thing that you need to be aware of is that you may potentially go to trial. And so in a DUI trial, there are usually 3 things that a prosecutor has to prove. 1, that you were, under the influence of either a drug or controlled substance or alcohol. 2, that you were driving or that you had access to or control of a vehicle. And the third thing that they usually have to prove is that you were impaired, right? And so if it's a drug, they have to show that the drug that they believe was in your system was actually a controlled substance. If it's alcohol, they usually have to provide the blood alcohol content. In some places, they may not have to provide the blood alcohol content. They may just only have to show that you were impaired. For instance, like in DC, there is a subsection of the DUI law that says that the prosecutor only has to show that you were impaired to the point that it was perceived or noticeable. That is so broad, but there's usually some type of general impairment statute in most states and jurisdictions where even if they can't prove a specific blood alcohol content or a specific drug, that it seemed as though you were impaired. Now, I don't know that I like the general impairment statute, but I'm just simply mentioning it because that is something that I've typically seen in multiple jurisdictions. So the fourth thing is that you can potentially go to trial. At trial, your attorney would potentially provide witnesses or evidence. At trial, your attorney can file motions, potentially a motion to suppress evidence if the police illegally stopped you, if they illegally detained you, if they illegally obtained information from you, without reading you your rights, assuming that you were already arrested. Just FYI, Miranda rights only apply if you are arrested and in police custody at the time. So if you're interrogated after you're arrested, the police are required to read you your rights. And if they don't, then at that point, those statements can be suppressed at trial. So there are various options that can happen at trial. Pre-trial issues to eliminate evidence or to get certain evidence thrown out, and then trial arguments as well to prove that perhaps you were not impaired or perhaps you were not under the influence or maybe you were not driving. So various trial arguments can be presented. So the fourth thing is that you can elect to go to trial, assuming that maybe you don't have a really good plea offer or you don't have a good program that would allow for a dismissal. And the final thing that you need to be aware of if you are ever charged with a DUI is that if you are found guilty, your license is likely to be suspended. Some states call it different things, suspended or revoked, but for the most part, the local Department of Motor Vehicles would have notice that you had a DUI, your license was suspended, and for the most part, you would probably have to pay some type of reinstatement fee in order to get your license back. I have seen jurisdictions where the Department of Motor Vehicles, they actually want to see that you completed some type of class in order for you to get your license back. So if you're found guilty or if you plead guilty and you have that DUI, then if it's a part of probation for you to complete the classes and you never complete it, you may have to complete it anyway just because the local DMV may require it. Not every jurisdiction is like this, but I have seen some jurisdictions that require a class for you to get your license back. So that is part two of what happens if you get a DUI charge. These are the things that you need to be aware of after you're charged with a DUI. So if you haven't seen the first part of the series, go ahead and check it out to see what happens if you're ever arrested for a DUI, so you know what rights that you have. And if you have any questions, feel free to comment them down below, and I'm always happy to respond to your comments. And if you have any further questions and you want to chat with me further, you can message me on my website, mydclaw.com, and I'm happy to chat with you further over there. As always, stay safe, take care, I'll see you soon.